Welcome to the Explainer. You know those ruthless win-at-all-costs shark lawyers you always see in movies and TV shows? Yeah, well, forget all of that. Today, we are diving into the very real, highly structured ethical code that actually governs South African attorneys. It's a genuinely fascinating look at what happens behind the scenes in the legal profession, and we're going to separate all that dramatic fiction from the rigorous, everyday reality. See, Hollywood loves to tell us that a lawyer's only job is to win for their client, literally no matter what it takes or who gets in the way. But the South African reality? It is entirely different. When an attorney is admitted to practice, they stand in the high court and take a solemn oath to be an officer of the court. And what does that actually mean? Well, it means their ultimate loyalty isn't to the person paying their hourly rate. It's actually to justice, the law, and the public. Now, to enforce this strict moral compass, the legal profession in South Africa isn't just left to govern itself on the honor system. It is heavily, heavily regulated. If you really want to understand who keeps these lawyers in check, there are two main things you need to know. The Legal Practice Act 28 of 2014, we just call that the LPA, and the Legal Practice Council, or the LPC. The LPA provides the legal framework, and the LPC, they are the ultimate watchdog. They're the regulatory body that strictly enforces the code of conduct. Okay, let's dive right into this. We're going to break down an attorney's ethical obligations into four main pillars today. First, duty to the court. Second, duty to the client. Third, public and professional duties. And finally, we'll look at exactly what happens when an attorney crosses that ethical line. All right, starting with pillar one, duty to the court. Now, what's really interesting about this is how it completely flips the script on what most people assume lawyers do. The court takes absolute precedence, as the code strictly states, if a client's instructions conflict with your duty to the court wins every time. Really let that sink in. An attorney is not a hired gun. Their absolute highest ethical duty is to the administration of justice. If a client wants their attorney to do something that compromises the court's integrity, the attorney literally has to say no. So, what does this highest duty look like in real life? It basically breaks down into three strict rules. First up, absolute honesty. An attorney must never, ever mislead or lie to a judge or magistrate. If they find out their client lied under oath, they absolutely cannot present that lie as the truth, period. Second, disclosing the law. Attorneys are ethically required to bring all relevant legal authorities, past cases, statutes, you name it, to the judge's attention. And here is the crazy part. They have to do this even if those past cases completely ruin their own client's argument. Yeah, imagine paying hundreds of rands an hour just for your lawyer to hand the judge the exact ruling that tanks your case. But you can't hide a law just because it hurts your position. And third, no abusive process. That means no frivolous legal tactics, no intentional delays, and no filing baseless pleadings just to waste the court's time or run up the other guy's legal bills. Moving right along to pillar two, duty to the client. So, yes, the court comes first, but the attorney's relationship with their client is obviously still incredibly important. This relationship hinges on one vital legal word, fiduciary. Being a fiduciary basically means occupying a position of absolute trust. An attorney must always act in the client's best interests. But, and this is a huge caveat that ties right back to our first pillar, they have to do so strictly within the bounds of the law. This fiduciary duty is really the heartbeat of the whole attorney-client relationship. In everyday practice, this breaks down into a few key areas. First is confidentiality, which you probably know as attorney-client privilege. Whatever you tell your attorney in professional confidence stays with them. They can't tell third parties, they can't tell the police, except in incredibly narrow circumstances, like if they find out a client is actively planning to commit a serious crime in the future. Second is competence and diligence. If a case is totally out of an attorney's depth, say they exclusively practice family law but take on a wildly complex tax dispute, they must either decline it or get expert help. They can't just wing it. Finally, avoiding conflicts of interest. A lawyer cannot act for a client if their personal interests or the interests of another client clash. A classic example here, you definitely cannot represent both the buyer and the seller in a disputed property transaction. And you certainly can't sue a client you're currently representing in another matter. Next up, pillar three, duty to the public and handling trust money. Attorneys hold a massive amount of power over people's lives and their finances. Because of this, there is a very strict dividing line in legal practice. On one side, you have the client trust account. This holds protected funds. Think your house deposit or road accident fund payout. On the other side, you have the firm business account, which is just the firm's operational money. Under the Legal Practice Act, an attorney has to keep these completely separate. Mixing client trust money with the firm's money or, using trust funds as a temporary personal loan to cover office overheads, that is an immediate, career-ending ethical violation. No exceptions. And that demand for integrity doesn't just switch off when the attorney leaves the office. An attorney must be what the law calls a fit and proper person. Dishonesty in their personal life, things like committing fraud, theft, or perjury outside of work, actually proves they are fundamentally unfit to practice law. Personal integrity matters profoundly here. Think about it. If you can't be trusted not to commit fraud in your private life, how can society trust you to hold the keys to someone's life savings? Which brings us to Pillar 4, duty to the profession and colleagues. To keep the entire legal system from just devolving into chaotic personal warfare, the profession relies heavily on mutual respect. First, professional courtesy. Attorneys have to treat opposing attorneys, advocates, and witnesses with dignity. Insulting or underhanded behavior isn't just frowned upon, it's an actual disciplinary offense. Second, honoring undertakings. In law, an attorney's word is their bond. If they give an undertaking, which is a formal professional promise, like promising to hold funds in trust, they absolutely must honor it. Breaking that promise is dealt with severely by the LPC. And third, no gazumping or poaching. An attorney cannot communicate directly with someone on the opposing side if they know that person already has a lawyer. Every single communication has to go through the legal reps to keep everything completely above board.
So, what happens when it all goes wrong? Let's look at crossing the ethical line and facing the LPC.
When an attorney actually goes rogue and a client lodges a complaint, the LPC steps in. They have dedicated disciplinary committees ready to investigate, and the punishments ramp up extremely fast depending on what happened. Step 1 is a formal reprimand or a warning for minor infractions. If it's more serious, we hit Step 2, an administrative fine. For major violations, it goes straight to Step 3, suspension from practicing law for a set period. And finally, for the absolute worst unforgivable breaches, like stealing from that client trust account we just talked about, we hit Step 4. The attorney is struck off the roll of attorneys by the High Court. That is the ultimate career death penalty. They lose their license to practice law permanently. So, it all boils down to this. Without this strict moral compass, and without the rigorous oversight of the Legal Practice Act and the LPC enforcing these rules, could we ever truly trust the legal system with our freedom and our finances? These ethical rules aren't just administrative red tape. They are literally the foundation of trust in the justice system. Thank you so much for joining me on this deep dive into the real ethical code of South African attorneys. I hope this gave you a whole new perspective on how the legal profession actually operates and protects the public behind the scenes.